Hello, everybody. Welcome back to the Diddy Docket. Today is Friday, November 29th, the day after the American Thanksgiving holiday. And we did get a ruling on Diddy's bail honestly, moments before the Thanksgiving holiday started. It was back on the 27th. So 2 days ago, the day before yesterday, the judge in Diddy's case finally did deny his bail. So, in today's episode, I want to get into the reasons that the judge gave for denying bail. And I also want to get into another document that we missed, the document that came right before this one. That was document number 91. And then the bail denying is document 92. Okay. So, in document 91, for those of you keeping up in chronological order like that, this is a letter from the government. Again, this is before Diddy was denied bail. This came one day before he was denied bail. And it had to do with a specific question that the judge did ask the government to answer. The question had to do with the applicability of the Boustani case to Diddy's case. Now, in the Boustani case, this is a case that Diddy's lawyers relied on in trying to get him out of jail on bail. And it had to do with where the government or the prosecution tries to use somebody's wealth as a big reason why they want to keep him in jail. So Diddy's lawyers were like, look, Your Honor, courts have already agreed that you can't do this. So the judge was like, I don't know about that, but let me actually get a full response from the government on the case. The government wasn't really prepared to talk about it that day at the hearing. So what the government did instead was submitted this 2-page letter to the court, just ironing out that last detail about the Boustani case. The government submits this letter in response to the court's inquiry, which means the court's question in the November 22nd bail hearing. This is the one that was a week ago today. It was a week ago, last Friday. And that's where the court did ask the question. And the question was about the applicability of the Boustani standard to Diddy's proposed conditions of release. The government says after reviewing the transcript, the government, that's the feds, recognizes it may have misunderstood the court's initial questions. To clarify, as set forth in the government's opposition briefing and at the hearing, the government is seeking the defendant's detention. Okay. So the government is seeking Diddy's detention based on what? His danger to the community, number one. Now, remember these reasons because we're about to read the judge's decision and he uses these reasons, okay? So the feds are seeking detention based on Diddy's danger to the community, which includes the serious risk of obstruction of justice he poses, as well as his risk of flight. So the main two big reasons why they are requesting that he stay in jail, or why they were requesting that he stay in jail, which it's already been decided now, are danger to the community, which includes him going out there and obstructing justice, which includes witness tampering, threats, kidnap, arson, etc. And the other reasons, that's number one, obstruction of justice. Number two, because he is a flight risk. Okay. That's according to the government. Because the government does not seek detention based only on Diddy's risk of flight, relying primarily on his personal wealth, the Boustani holding applies here. And I said this too. I said, well, the Boustani case might apply if they were only seeking detention based on risk of flight. Like, okay, Your Honor, he has so much money, he can just get on a plane and leave. But they're also not just worried about him going away. They're actually specifically concerned that he will not just go away. He will perhaps put other people in danger, and he will perhaps obstruct the trial itself, not allowing the government to, get the justice it's seeking. So two big reasons they're using are obstruction and flight risk. But in the Boustani case, they're saying the government wasn't alleging or arguing in his case that he was specifically a danger to the community. Now, in the Boustani case, I think I remember he was actually a gang member, a mafioso or something. So they might should have argued that in that case, but they did not apparently. So it says, on the other hand, the holding of United States versus Subnani is inapplicable. So they're also distinguishing this other case, Subnani. The Second Circuit in Boustani clarified I don't know if it's Subhani or Subnani because they spell it two different ways. They need to figure that out. But They're just they're just basically reminding the judge or maybe clarifying for the judge that they are not seeking detention only because he's rich. They're seeking detention because of this arson, the kidnap, all other stuff. He's a danger to the community. He's a danger to the witnesses. He's a danger to the trial, right? All that stuff. Okay, so that brings us to the main event here, and that is the judge's order denying bail to Diddy for a third time. Okay. Defendant Sean Combs, let's just start reading it here. This is document number 92. Defendant Sean Combs renewed his motion for bail on November 8th, 2024. So that was 21 days ago. The court held a hearing November 22nd, and the parties filed supplemental letters on November 25th and 26th. For the following reasons, Diddy's motion for bail is denied. Now, the main reason for this is that there is no condition or combination of conditions that will reasonably assure the safety of the community. Now, you might remember there were two grounds that Diddy's lawyers were trying to get him out on. One was that proposed bail package. They were saying, look, Your Honor, under the following conditions, it's going to be just fine for you to let Diddy out. He's going to have private security. He's going to have this house in Manhattan. He's going to give up his passport, all this stuff, right? The other reason that Diddy and his lawyers were asking for bail, which was kind of like, okay, let's say that doesn't work out for them. Let's say that first one doesn't work out. They were also arguing that the conditions of Diddy's confinement at the Metropolitan Detention Center were basically so bad and so horrible that he needed to be released in order to prepare for his trial. Okay. So the first reason that the judge does get to is the first one I mentioned, which has to do with the bail package and whether or not it's actually even possible to trust Diddy out here under any possible set of conditions. So the judge says, no, there's not. I can't trust him, essentially. The court has evaluated each of the factors it must consider under the statute. Number one, the nature and the circumstances of the offense charged against Diddy. Number two, the weight of the evidence against the person. Number three, the history and the characteristics of the person. And number four, the nature and the seriousness of the danger that would be posed by Diddy's release. So these are all of the factors that the statute requires the court deal with, okay? Nature and circumstances of the offenses, but also the quote, weight of the evidence against the person, okay? So not only what is he charged with, but what have they actually presented evidence for? And number three, the history and the characteristics of the person, which in this case is Diddy, and the nature and the seriousness of the danger that would be posed by Diddy if he were released. Okay, those are the things, the four things that the statute requires the judge to look at. So not just how serious the charges are, but is there evidence? Is there evidence of a history of any type of behaviors? How serious of a danger would be posed by Diddy getting out? Would it be a little danger? What would the danger be? Or would it be a very serious danger? Okay, those are the things the judge is considering. The court has also reviewed the information submitted by Diddy and the government across all three bail hearings in this case, and he lists out the docket numbers. The court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community. In support of this finding, the court provides the following reasons. Okay, so the court is giving a few reasons in this opinion for making his decision because it is definitely going to get appealed if the past is any indication of the future. So the judge is kind of laying it out for the next judges that it gets appealed to. Here you go. These are the reasons I made my decision. Good luck. Number one, the rebuttable presumption of detention. Now, this is a fancy way to say there is an assumption, okay? In layman's terms, there's an assumption that Diddy has to stay in jail because specifically under the Bail Reform Act, Diddy is charged with ST ficking. And because he is charged with that type of a crime, with that level of a crime, a charge, it's allegation, it's a charge until proven. But because he is alleged to be doing that serious of a thing, including arson, kidnap, ST, and all the rest, there's a presumption and assumption under the statute, the Bail Reform Act, that Diddy is going to stay in jail. Okay. But rebuttable because he could have tried to argue that there was some way he could be set free and he wouldn't pose a danger to the community, et cetera, et cetera. But in general, it's presumed he's staying in jail and he has to overcome that by proving himself to the court that he could be trusted. He was unable to do that. Okay. Remember, what we are doing is reading the judge's reasons. The following reasons are the reasons that the court gives for making his order. There's a rebuttable presumption that Diddy needs to stay in jail. But it says, even if Diddy successfully rebuts or kind of overcomes the presumption that he needs to stay in jail, it remains one of the factors that the court considers in determining whether the government has met its burden of persuasion. Okay. Then they have this footnote down here. Okay. So this is very important. I didn't even read this. I didn't even catch this the first reading around, but this is why I got to always look at the footnotes. We do have 2 footnotes on the first page. Footnote number 1, I don't even know where they put the footnote number 1. Do y'all see it? Well, it's down here. Whether or not information submitted by Diddy in his renewed motion meets the statutory standard for reopening a detention hearing, the court still exercises its inherent authority to review the entire record. So this is just kind of getting it on the record what authority he's using. Is he using the authority under 18 USC, or is he using his authority that gives him the inherent authority to review the entire record? And he says he's using that authority. But look at footnote number 2. So it follows this sentence right here. The court finds that the government has shown by clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of the community. Footnote number 2 says, given this finding, the court does not reach the question of risk of flight. This is very important. Okay. None of these judges, except maybe Judge Andrew Carter, have addressed really meaningfully the risk of flight, but they do all decide to keep Diddy in jail based on the fact that he is a danger to the community. They're not actually deciding on the flight risk question, because you remember when I kept talking about the table and it has all the 5 legs and all that? One of the legs is flight risk. So even if Diddy could appeal this case, he's going to have to overcome the question of being a flight risk, which he has never been able to get a court to decide he is not a flight risk. Okay. In fact, either 1 or 0 of them have even determined the question of if he's a flight risk officially on the record. So the judge is just saying that he's considering the entire record. So then the judge gives his number 2 reason. Okay. So the number 1 reason is there's a rebuttable presumption of detention. There's a presumption. There's an assumption Diddy got to stay in jail. And so number 1 reason why Diddy's staying in jail is there's a presumption he has to stay in jail. The number 2 reason the judge gives, and you see he even numbers his paragraphs, the indictment. Remember the stuff we have to consider. He has to consider the nature and seriousness of the charges offense, the weight of the evidence. So now he's going to get into the nature and the seriousness of the charges, right? And then after that, he's going to have to get into the evidence, which you can see by a little pre-foreshadowing here. They do get into evidence in the very next paragraph. The judge does, okay? So number 2, again, they're going to be talking about one of the things he has to consider, which is how serious are the charges against Diddy. He says the indictment charges Diddy with serious and violent crimes. It alleges for decades Diddy abused, threatened, and coerced women and others around him to fulfill his desires, protect his reputation, and conceal his conduct. To do so, Diddy relied on the employees, resources, and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other crimes, trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. The indictment says that Combs himself carried or brandished pew to intimidate and threaten others, including victims of and witnesses to his abuse. Then there was, we're getting into some of the real, actual evidence. This isn't just allegations, it's direct evidence, right? 3 AR-15s, if you know what I mean, with defaced serial numbers, as well as a drum magazine. When Diddy's authority or reputation was threatened, the indictment alleges, he and members of his enterprise engaged in acts of violence, threats of financial and reputational harm, and verbal abuse. These acts of violence, including kidnapping and arson, according to the indictment. The indictment also charges Diddy with ST in violation of 18 USC 1591, requiring the court to consider the nature and okay. So they just reiterate that he has to consider this because it did involve firearms. Okay, so then the judge gets into the evidence. The government has presented direct evidence of Diddy's violence. This includes video footage from 2016. Now look how easily the judge just handles that little allegation about it was tampered, et cetera, et cetera. Okay. There is clearly violence, the judge says. Okay. Even in the version of the footage submitted by Diddy. Okay. The government presented the video. Diddy took issue with the government's version of the video. So the judge is like, all right, I looked at Diddy's version. He's still violent. Okay. That is evidence. Sorry to tell you. I don't give a if he threw the vase or the contents of the vase. I don't give a if he was dragging her to an elevator bank or to a freak off. I don't give a why he was kicking her in the back of the head. It shows he is a violent person, and the government presented that public evidence. Sorry, Charlie. Now they say, in addition to that, the government's evidence, quote, direct evidence of Diddy's violence also includes text messages between Diddy and who we all presume to be Cassie, victim one, text messages from the hours and days following the 2016 incident where Cassie says, I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done. I still have crazy bruising. Nevertheless, Combs argues that the weight of the evidence does not support a charge of ST. So nevertheless, besides all the evidence that we all saw, the text messages and the video, Diddy argues that the evidence doesn't support a charge of ST, but rather it supports at best a quote, toxic, sometimes violent, long-term relationship between Diddy and victim one. But regardless of whether that's true, there is compelling evidence of Combs's propensity for violence. This is a very important factor to me because the judge is saying, now the judge isn't going to be the one who decides this case, a jury is. So they're going to have to convince a jury of the same thing, but the government has been able to successfully convince the judge that even if Diddy is right, that him and Cassie had a really violent, toxic, long-term relationship, it's like, it doesn't matter. Even if that is true, Diddy has shown a propensity for violence, according to quote, compelling evidence, according to the judge. This is the part where he has to consider the history and the characteristics of the person. So they're saying he's a violent person. When they're up here, the judge is like, look, remember, these are the things I have to consider. And if you think about these rulings at the trial level or the pre-trial level in this case, if you think about it as if the judge we're looking at is kind of like the associate and he has bosses as well, in addition to we the people, and his bosses that are going to be reviewing what he did is the appeals court, which we all are pretty sure it's going to be going to the appeals court. So he's kind of saying, look, bosses, these are the things I considered. The weight of the evidence, da-da-da. Okay, so now I got to consider the history of the person and the characteristics of the person, which he does do here. The court considers the history and the characteristics of the person, and that is that there is compelling evidence that he has a propensity for violence. Okay, so they are characterizing, the judge, the court is characterizing Diddy as having a propensity for violence. That is a big finding for the court to make. And this is, again, based on any version of the video, even Diddy's version he submitted. Number 4, there is also evidence supporting a serious risk of witness tampering. For example, Diddy initiated and had unexplained communications with witness 1, who was subpoenaed to testify before the grand jury in June 2024. And in fact, he did testify in July. Okay, so this witness 1, we've talked about this witness before. He is a grand jury witness. Diddy was represented by a lawyer during this time, and they have offered an explanation for some of these communications, but the court says they could not explain them all. For instance, remember, think about it as if you're writing it straight to the appeals court and letting them know what you based your decision on. For instance, one of the communications that Diddy and his lawyers just really couldn't explain as far as witness 1 were his efforts to call and text the witness, quote, even after the witness's grand jury testimony. And they also were unable to explain how Diddy's texts with witnesses got deleted, or with this specific witness got deleted. And then they're quoting some filings or a transcript or something here, but it's part of the docket number 69, if you want to go back and look what that is, at 10 to 11, quote, although the phone records confirm that this defendant, using a particular phone number, that's Diddy with a phone number, And witness one exchanged multiple text messages from June through August. There were no such messages recovered from Diddy's cell phone. So the judge is like, look, here's the evidence. He's a risk to mess with this trial. Number one, he's contacting witnesses after grand jury testimony by call and text, or attempting to. He's also deleting evidence, which is texts with grand jury witnesses. Further, the court says, so that's not the only two evidences, right? He's giving all the very important evidence to the appeals court to let them know you need to keep this man locked up. Further, Diddy's interactions with witness one are directly, okay, now he's going to start coming from Mark Agnifilo. And I believe that Mark Agnifilo needs to start watching his back as far as this judge is concerned, because I think he has shot his credibility in the foot. I do. Look what the judge says. Further, Combs's interactions with witness one are directly in conflict with Diddy's lawyer's representations to Judge Carter, with Agnifilo's representations to Judge Carter on September 18th, whenever he said that Diddy did not reach out to any grand jury witnesses. He didn't do it, and he wouldn't do it, and he has the sense not to do it, and all that. So the judge is saying, oh, also, I can't trust what the lawyer is saying either, just so y'all know. Okay, paragraph 5, the judge says, there is evidence that Diddy violated Bureau of Prisons regulations during his pretrial detention to obscure his communications with third parties. He paid other inmates to use their phone access code numbers to make calls to those not on his approved contact list, okay? He instructed family members and his lawyer to add other people to three-way calls so that their communications were more difficult to trace. And he used a messaging program called Contact Me ASAP. Although the court recognizes that the parties dispute whether Contact Me ASAP is permitted or not. Okay, so the judge is saying, I understand the parties are disputing it, but the evidence definitely is clear. He definitely broke some regulations and rules of the Bureau of Prison, even though maybe not just specifically on this Contact Me ASAP aspect, but he broke some rules, the judge is saying. The government gives examples of his communications using these means from as recently as this month, his birthday, November 4th, directed to efforts to influence the jury pool or to reach out to potential witnesses. Okay. The court makes no determination. This is important. The court is not making this determination based on the actual content. I don't need to read the text messages to know what Diddy's intention was and what the real danger is. And the judge says it was his willingness to skirt or kind of break the Bureau of Prison rules in a way that would make it more difficult for his communications to be monitored. The judge says this is in itself strong evidence that the court cannot be, quote, reasonably assured as to the sufficiency that there is any condition under which there's not a bail package he could send to me that would let me let him out, is what the judge is saying. And one of the reasons, other than he's violent, other than this other stuff, one of the big reasons is he is breaking the prison rules, regardless of the content of the messages, regardless of his intention to want to contact a jury, regardless of his intention to want to do a PR push campaign, and regardless of what the messages actually in and of themselves say. The judge is saying the fact the man is willing to break the rules of the prison in a way that ultimately results in the prison having a harder time tracking his communications, that in and of itself is strong evidence that there's no way he's going to listen to my rules if he's not following the prison rules. But the judge does go on. He says, especially given that these actions occurred when Diddy was seeking bail and when he knew the government's concerns about witness tampering and obstruction were front and center. So Diddy knew, he had the awareness that the government was concerned about him breaking prison rules. And Diddy had the awareness that he was in jail when he was doing this stuff. And yet he still did it, is what the court is saying. Underscoring the court's concern, despite Diddy's lawyers' assurances to the court. Look, again, they are calling out Diddy's lawyer yet again for a false statement. Okay, look here. Directly, Diddy's interactions with witness one, which is evidence, right? Because the judge has been able to see the evidence now with his own eyes. That evidence is directly in conflict with the representation that Agnifilo, Diddy's lawyers, made to Judge Carter. On top of that, he's calling the lawyers out again right here. The judge is saying, despite Mark Agnifilo's promises that Diddy has stopped using Contact Me ASAP as of November 16th, the government indicates through evidence they submitted that Diddy has continued to use Contact Me ASAP as recently as this past Sunday. Last Sunday, not even a week ago, November 24th. So the court's saying, look, I hear the lawyers are out here saying, oh, my client obeys me. Oh, he's not using that app no more. And he's still using it. He's still using it even after he stood up in court and the lawyer stood up in court and said he's not using it anymore. Yes, he actually still using it, is what the judge is saying. That's one of the reasons that he's basing his decision. That was in paragraph 5. Now he moves on to paragraph 6. The court further notes that it held an emergency hearing. Okay. Emergency hearing. Remember that on the whole legal pad of it all? Huh. The court held this hearing November 19th to address the government's usage of notes on legal pads recovered from Diddy's bunk during a sweep of the MDC. And then the judge reminds and reiterates in footnote 3, in reaching my decision, I do not rely on Diddy's notes, the judge is saying, from the MDC, which he claims are privileged, and which the government agreed the court need not consider. Okay, so he's saying, I'm not relying on anything that I actually saw in them notes. I'm not even reading the notes. What I'm talking about is what happened in the public court hearing. And he goes on to say right here, at that hearing, defense counsel, again, Mark Agnifilo, advised, quote, all these legal pads say legal. Yes, they're marked as legal. And this is docket number 88 at line 34. I believe that is a transcript. I don't have access to it. I think I would have to buy it. I don't even think we can get it yet. After the hearing, the judge says, the court inquired why, in light of Diddy's lawyer's representation that the notes at issue were on legal pads that were clearly marked as legal, the court asked why it was then the case that the photographs taken during the sweep shows no such label. So here's Mark Agnifilo. Oh, it says legal. It says legal. But the pictures, the actual evidence the government actually has a picture of doesn't say legal. And so the judge is really talking about that here. And remember, he was the one that made an order ordering Diddy's lawyers to be prepared to answer for themselves at the hearing about that. The judge goes on to say, though, at the November 22nd, 2024 hearing, Diddy's lawyers admitted that, quote, it has to be the case that as of the day of the search, legal wasn't written on every legal pad and that they were not sure. Diddy's counsel said they were not sure whether the pad presented to the court said legal on it at the time of the sweep. The circumstances of this incident, the judge says, and the, quote, misrepresentations made. Okay, so this sentence is a big 1-2 punch, okay? The circumstances of the incident and the, quote, misrepresentations made. That is a fancy legal word for saying false statement. And who's making the misrepresentation? It could be ambiguous, right? The misrepresentation made at the hearing. But the judge tells us who he thinks is responsible for the misrepresentation. And it's not Diddy. This is another thing that I predicted, that somebody was going to get in trouble for this, but on this particular one, it could probably be more likely to be Diddy's lawyer. Now, that might be tomato as far as y'all are concerned, because doesn't Diddy get punished for it in the end anyway? The misrepresentation, the judge believes, was made on the part of the lawyer, Mark Agnifilo, not Diddy. Look at the sentence. The circumstances of this incident with the legal pad and the, quote, misrepresentation made at the November 19, 2024 hearing. That was an emergency hearing they called about this specific issue. And the misrepresentation made at the November 19, 2024 hearing where Combs was present. Okay, so the judge is saying this all happened, the misrepresentation made, not by Combs, no, by the lawyer is what you have to read between the lines. The misrepresentation made at the hearing where Combs was present. Right? Combs was there and watched and saw and heard and experienced the misrepresentation be made. By who? His lawyer. So the judge isn't even saying Diddy lied. The judge is saying somebody misrepresented to me. And Diddy was sitting right there and did not correct the record. He allowed the false misrepresentation to stand. The judge said all of that bears on whether or not I can be reasonably assured that any condition would even be followed. Okay, look, any conditions it imposes would be followed, or whether through, quote, inadvertence or active subversion, they will be broken. This judge is very smart, y'all. The man is smart. He's very thoughtful and he's really smart. He's using good arguments, strong arguments that make logical, legal sense. He's already predicating, he's predicting that even if Diddy says, well, that was my lawyer, he got it wrong. The judge is saying, I don't care. You could blame your lawyer for that all day long. You were sitting in court. You didn't correct the record. And so what if somebody's breaking a rule out here in your apartment? Are you going to correct or are you going to tell the court? No, you're not. That's what the judge is saying. Number 7, the court assumes it may consider the bail package that Combs has proposed. So it's not saying the government has argued. The feds have argued, Your Honor, you can't even look at this bail package. You cannot even consider it. It's already been decided. The court says, all right, you know what? No, I'm going to side with Diddy. I'm going to consider his bail package. He says, but Boustani, remember Boustani from docket number 91, where the feds wanted to reiterate how it was different than Diddy's case. And then Diddy wanted it to be kind of like his case. The judge is using Boustani, but he's using it against Diddy. Quote, we now expressly hold that the Bail Reform Act, this is from case law, this is from the Boustani case. The Bail Reform Act does not permit a 2-tiered bail system in which defendants of lesser means are detained pending trial, while wealthy defendants are released to, quote, self-funded private jails. However, given the nature and the allegations in this case and the information provided by the government, the court doubts the sufficiency of any conditions that place trust in Diddy and individuals he employs, like a private security detail, to follow these conditions. Okay, so given the nature of the allegations in this case and the evidence that the judge has seen, the judge doubts that any conditions could be sufficient to place any trust in the hands of Diddy or individuals he employs, like a private security. The judge is saying, I don't trust no private security by Diddy. And the reason is because the nature of the allegations and the information that the government provides, which includes evidence. He cites another case, United States versus Gorianna, where a proposal, quote, at best elaborately replicated a detention facility without the confidence of security such a facility instills. The court, okay, so the judge is basically saying Diddy pretty much just wants to like pay for a private prison in his apartment, and I'm not doing that. There's case law that says I can't do it. The judge says the court observes that pretrial services, right, the people who would be responsible for administering the ankle bracelets and the this and the that's and all of that, pretrial services also reached the same conclusion, noting at the bail hearing on November 22nd that the conditions are insufficient and there are no conditions that could reasonably assure the safety of the community. Okay, so he's also throwing in there pretrial services also agrees they're not going to be able to feel comfortable or confident that he can actually do any of the things that they would put in place either. The final paragraph that the judge gives, the final reason that the judge gives for denying bail on the first grounds, which was the proposed bail package. Remember, there's a whole second grounds that the judge also obviously denies bail based on, but the second grounds has to do with the conditions of the facility. We will get to that, but we're still on the no conditions, reasonably assure that Diddy will not be a danger and all that. Okay, so the final paragraph there, 8. Finally, the judge says, the facts and circumstances here differ from those in Combs's principal cited authorities. So he cites authority in Fox, another case law case, United States versus Fox, 2022 Second Circuit case, where that case was an extremely close call, and that any loosening of conditions or more compelling evidence presented by the government would tip balance in the favor of detaining the person. So the judge is saying the main case that Diddy relies on actually was a very close case. And if the government would have gotten some more evidence in on the record, it would have tipped in favor of making that person be locked up. Okay, so in the case where Diddy tries to rely on, it's called Fox. He also relies on Jeffries, the principal, the Abercrombie case. But the judge is saying In the Fox case, yeah, they let that guy out, but it was a very, very close call. It wasn't like an open and shut, easy case. And then on top of that, in the Fox case, the government, the feds, were not accusing Fox of obstructing, and the government failed to engage with the proposed bail restrictions. So those were two different ways that Fox really wasn't the same as Diddy's case. Okay. That was an important matter. Diddy's saying, look, I'm just like Fox, so you have to let me out of jail. And the judge is saying, no, you are not. Because, first of all, Fox wasn't accused of obstruction, and that's the reason we're keeping you in jail. So there's a big freaking reason right there, buddy. And then the second reason is that in the Fox case, the government just didn't even talk about or think about or look at his proposed bail package. But in Diddy's case, they actually did. And they looked at all the conditions and they said none of this would reach what needs to be reached to keep the community safe. Then the judge moves on to the Abercrombie case, where he was let out of jail pretty recently on bail. While the government raised danger, its principal concern with respect to defendant Michael Jeffries was flight. Okay. Their principal concern with Michael Jeffries, the Abercrombie former CEO, was he was a flight risk. That's why they wanted to keep him in jail. He had no criminal history. The alleged. Hello? Bye. Okay, somebody just called me. I don't exactly know where I was. Let me just start like somewhere around here. He had no criminal history, and the alleged criminal conduct, which did not involve the kind of violence or RICO allegations made here, abated nearly a decade ago, and Jeffries was 80 years old. Now, I did do a whole video on this, maybe even 2 videos on this, so I'm not going to rehash how the government was arguing Jeffries and Diddy were different. But suffice it to say here, in my opinion, on this brief reading TLDR, the judge did go with and side with the government in this case. He found their differentiation to be compelling. Type of things they're being charged with: RICO, Diddy's being charged with RICO, which is the Racketeering Act. Jeffries is not. The criminal history, which speaks to the characteristics of the person and stuff like that. So the judge did seem to pretty much on the full wholesale side with the government. So now the judge gets to very short, 1 paragraph addressing of the conditions in the prison. And I think it's really interesting that the judge actually leaves the door open for Diddy to come back again looking for bail. And if the past is any indication, I think it might be soon. It says Roman numeral 2, Combs' motion for temporary release is denied. The court also finds that Combs has not shown that a temporary release from detention is warranted. Under 18 USC 3142I, a judicial officer, a judge, may, quote, permit the temporary release of a person in the custody of a United States Marshal or other appropriate person to the extent that the judicial officer determines such release to be necessary for the preparation of the person's defense or another compelling reason. Diddy's application is based on the conditions at the Metropolitan Detention Center, which Diddy says, make trial preparation impossible. But given Diddy's access to counsel and documents, the judge says there was an issue with Diddy receiving a laptop for the purposes of reviewing discovery, but the court addressed that. The firm deadline for the government's discovery and the time left before trial, Diddy has not carried his burden of demonstrating that release from detention is necessary for pre-trial preparation under Section 3142I or the Constitution. Remember, Diddy and his lawyers were also arguing that Diddy had a 6th Amendment right to have access to his lawyers. The judge is saying there's a few things he's considering here. Number 1, they have 5 months to prepare for this trial, which is a long time. Another factor or variable is that there is a firm deadline for the government's discovery. It's not like this is going to go on forever and ever. Like, we have 1 more month pretty much of discovery because it ends at the end of this year, and the government has to give all of its documents and evidence over that it has in its possession by the end of the year. The judge said based on those reasons, Diddy has not carried his burden of demonstrating that release from jail detention is necessary for trial preparation purposes under neither the statute 3142I nor under the 6th Amendment. Okay, but listen to this. The judge says just right there, the sentence just gets cut off even at the end of the page. But the court will promptly address any issue that arises with respect to Diddy's trial preparation. And if the circumstances materially change, Diddy may renew his bail application. Okay. The motion is denied. The clerk of court is respectfully directed to terminate docket number 60. Okay. So the judge says, no, you staying in jail. And the judge all but calls Mark Agnifilo a bold-faced liar on more than one occasion. I mean, we're talking about the legal pad issue. We're talking about the contact me ASAP issue. We're talking about the contacting a witness issue. I mean, it's 3 issues that the judge raised that the lawyers were not giving true statements. Okay, that's an issue. He says, also, I will address anything that comes up under this 3142I. Not everything that comes up needs to be, motion to let him out. You could have motioned. The judge is kind of, reading between the lines. You can read between the lines. He's kind of saying you could have motioned to let the laptop come in a lot sooner. You could have motioned about that, but instead we've been out here fighting about letting Diddy out of jail instead of getting a laptop into the jail. You see what I mean? But the judge, again, I think so fair, and it makes me hopeful that Diddy is going to get a fair trial, because what is going to happen if Diddy does not get a fair trial and he is able to prove that he did not get a fair trial is he's going to have the charges probably dismissed, a mistrial perhaps declared, and maybe he doesn't actually pay any consequences for his behaviors. Okay. So for me, it is primary and very important that for even if only that reason alone, he get a fair trial. But I actually do believe in the notion of a fair trial, and I think everybody should get one. I do. If somebody did something, fair trial on both sides should be followed, and they should still be able to get the person, you know what I mean, on doing the thing. The judge is so fair. He's saying, if something else comes up in the future, bring it to me and I will address it, even though y'all lied to my face 3 times. And if Diddy's circumstances materially change, letting the jail know, this isn't forever. So y'all better keep it together, and you better have your act together. Okay. Because if y'all start picking on Diddy and it gets worse in there, I might let him out. He may renew his application under the statute if his circumstances in the jail change. So that was pretty much all that there was for that. This video ended up being quite a bit longer than I originally anticipated, but this was a very important docket item. So I'm glad that I did spend the time doing it. That's all I really had for right now. I'll be back if anything materially changes. And in the meantime, facts ain't defamation and neither are opinions, girl. Love you, Mina. Bye.
Welcome into my world. You're playing my game. Thought that you could come up and they're fitting off of my knee. Talking out the side of your neck like you're insane. Cortisol levels to the roof. Inflame. Kids these days so shameless. Selling out real friends for a paycheck. Mama didn't teach them no home training. Wanna be me so bad, but they failing. Step to the plate though. I'll take a challenger. I ain't scared of no low life scavenger. I should warn you though, if you haven't heard, I ain't no Colleen ukulele ballanger. Shots been fired. Run and tell that. Say it to my face though. Now behind my back. Won't be long till you share it in the group chat. And when I call you up, you're gonna backtrack. And you should've kept my name out your mouth. As we go, how it all turned out.